So this question of the secrecy of death penalty lethal injection chemicals is urgent and profound and timely, but it's also a symptom of a larger issue. We seem to be at an interesting inflection point in our long national engagement with the death penalty. And just to give you a tiny bit of background, and we'll hear more from our distinguished panelists, whom I'll introduce in a second. We are now down to, in 2014, 35 executions, 72 death sentences. Obviously, every one of them is terribly important, but that's a vanishingly small number in the context of the American criminal justice system, which has 2 million, more than 2 million people in our prisons and jails, and 10% or more of prisoners are serving life sentences. So one thing to think about the death penalty is as a kind of resource allocation question, and I don't only mean dollars. I mean in attention, in judicial attention, and litigation attention, is all the time we spend on the death penalty, also distracting us from, and all you need to do is open a newspaper to see it, distracting us from other wrenching problems in the criminal justice system. Now, people like to say that support for the death penalty is dropping, and that's true. But I think an honestly held poll will still tell you that a majority of Americans, in principle at least, are prepared to accept the death penalty in some cases. So I don't know that too many people are terribly upset that the Boston Marathon bomber is going to be put to death among Americans. And I think we fool ourselves to think that there isn't that kind of popular, in principle, support for the death penalty. At the same time, you put those same people on a jury, and they are these days very reluctant to impose the death penalty because they've heard a lot about the shortcomings of the system and about exonerations from death row and so on. So there's this in principle, in practice distinction that perhaps will come up. We have seen two things recently that may tell you something about where the country's heading. To the shock of almost everyone concerned, the unicameral Nebraska legislature, very conservative state, overrode a governor's veto to abolish the death penalty there. That seems to me a signal turning point in American death penalty history. We also had, a month or two ago, a very heated argument in the Supreme Court in a case about whether a given death penalty drug violates the Eighth Amendment's ban on cruel and unusual punishment. From the tenor of the argument, my sense is that the court will yet again not intercede in how executions are to be conducted. Maybe I'll be proved wrong. So we have here a court that has not hesitated to cut back on the categories of people who can be executed, cut back on the sorts of crimes that can warrant the death penalty, but doesn't seem to me either to be ready, anywhere near ready, to take the ultimate step of abolishing the death penalty, or even the interim step of telling states how they should be conducting executions. But maybe we'll hear different views on that. So we have a really strong panel today to talk about some of these issues. And I've asked them to do two things, even though our ultimate goal is to bear down hard on this question of whether states can keep their death penalty chemicals secret, to also put it in a larger context. We're going to hear first from Tanya Green, who is the Advocacy and Policy Counsel at the American Civil Liberties Union and has worked to defend convicted death row inmates. And then from Mark Early, who was Attorney General of Virginia and served in the Virginia Senate, and now is on the Death Penalty Committee of the Constitution Project. And I think we'll hear some real insights about fast evolving political trends in this area. Then Megan McCracken, who's Eighth Amendment Resource Counsel at the Death Penalty Clinic at Berkeley Law School, and works on the Death Penalty Clinic there. And finally, somebody who shares my background in a sense. I was a media lawyer for many years, Katie Townsend, who's litigation director of the Reporters Committee for Freedom of the Press, who will bring that angle of what rights, obviously the death row inmate might like to know how he's going to be killed, but do the press and public have an independent right to figure out what is going on in the final stages of that aspect of our criminal justice system. So I'm going to ask Tanya, first of all, to give us some general thought about trends, statutes in this area, litigation, what seems to be going on the ground.
Thank you. Thank you. Thank you to ACS for inviting me to participate in this panel. I hope that we're able to share some useful information and hear some good questions and have good exchange later on. So I've been asked to set the stage a little bit, describe what's going on in the death penalty arena. And Adam started, let me give a little bit more. So there are 31 states now that have the death penalty, plus the military and the US government. Just last month, there were 32 states. Things are changing. We have now 19 states without the death penalty. 7 states have repealed since 2007, and no state has reinstated the death penalty, which indicates the movement away from the death penalty. The tide is turning, things are changing. The popularity of the death penalty is waning in lots of arenas. And so the state status is one of the kind of biggest, most obvious ways to see that. The repeal in Nebraska last month is so significant, as Adam mentioned, because this is the first red state that's done this since North Dakota, and has done it in recent memory, and has done it resoundingly, almost 2-to-1 override vote in the final vote, and other votes in the legislature prior to that particular vote indicated even more strong support and less support for the death penalty. It was decided in Nebraska as a policy matter, not, as Adam indicated, about yay or nay on the death penalty itself, whether or not it is the right thing to do, but actually this is bad policy. This is expensive. It doesn't work. We're not able to implement it, and so we need to turn to better solutions. And so that's part of where we're going on the death penalty. There's, kind of the moral objection and problems folks have with it fundamentally. But then there are even more practical problems that are taking hold as we see how it's impossible to be fairly implemented in any way. So other indications about the trends that the country is moving away from the death penalty is the reduced executions. As Adam mentioned, we had only 35 executions in 2014. We've only had about 15 so far in 2015. That number from 2014 is the lowest execution number in 20 years. The highest point was 98 in 1999. And over the past 10 years, we've had an average of about 45 executions. And only 7 states of the 32 that could execute last year executed. And that's also another indicator of how narrow the field is getting in terms of active states on the death penalty. So more states have the death penalty that don't act on it than states that have it that do. And given their lack of executions in the past 10 years, 7 more states can be considered de facto abolition states in a way because they haven't executed in 10 years. And those states are New Hampshire, Kansas, Montana, Wyoming, Pennsylvania, Oregon, and Colorado. 4 states have active gubernatorial moratoria on executions as well, Oregon, Colorado, Pennsylvania, and Washington, which further reduces the activity of the death penalty and activity of executions and speaks to an absolute, the growing distaste, distrust, and disuse of the death penalty. Other reasons that executions have, or some of the reasons that have contributed to the reduction in executions include changes in law. In 2002, the Atkins decision exempting intellectually disabled from death eligibility, and in 2005, the Roper decision from the Supreme Court concluding that executing children who committed murders when they were under 18 violates the Constitution as well, further limited the categories of people that are eligible. And then drug availability, which is getting to the topic of today's panel, has been a real question and a real problem for states that want to kill their own people since 2010. Companies have stopped manufacturing drugs that have been being used and refused to sell execution drugs to states. Drug supplies have expired and gone bad. States have turned to compounding drugs in their stead, changing the different drugs that have been used and been approved by the various protocols that have been implemented across the states. And the compounded drugs have minimal There's minimal oversight, minimal regulation. They're fraught with potential problems. The pharmacies that do the compounding often have never done it before with a goal of killing the patient, such as it is. And there have been terrible botched executions as a result, as we've seen last year. 4 executions, arguably more, but 4 that we were able to actually visibly see evidence of botching. My colleague Megan McCracken is going to talk more about that. 3 separate pharmacist organizations, one as recently as early this week, late last week, have issued statements and passed resolutions saying that there should be no more involvement. It's unethical, inappropriate, and discouraged for these groups to be involved in executions. The AMA Code of Ethics also says that doctors should not participate in executions. It violates the Hippocratic Oath to do no harm. All of this is contributing to the reduction in executions in recent years. And then we also have the reduction in new death sentences. That's been also very significant development in recent years. We had the 72 new death sentences that Adam mentioned for 2014, which is the lowest number in 40 years. Only 18 states of the 32 that could handed down new death sentences in 2014, and only 2% of the counties in the country only 2% of the counties in the U.S. produce more than 50% of the death sentences that come out of the various counties that wish to do it. And that lopsided geography is more telling, that there's real popularity of the death penalty in some places for different reasons, and we can go into whether or not it's real popular, if it's real popularity itself, or if it's just means to an end politically, or there are different fiscal decisions that are being made regarding whether or not the death penalty would be sought in those counties. But it's only 2% of the country, basically, that produces more than half of the death sentences. The new death sentences have also been impacted by the changes in the law in limiting eligibility of cases. Polls do show that the support for the death penalty has been decreasing, that at this point Gallup last year concluded that the support for the death penalty across the country is the lowest that it's been in 40 years. That's the modern era of the death penalty. And that's significant. People's answers change depending on what alternatives are presented during polls and whether or not alternatives are presented. But it's clear that the support for the death penalty is lower than it's ever been in the modern era. Just this last week, there was a Quinnipiac poll that concluded when pitted against life in prison without parole as the other alternative, the death penalty brought 43% of the support, and the life in prison without parole garnered 48% of those polled. And that's significant because support for the death penalty peaked in around 1994 at 80% of the population, hands down, no question. And things have changed. That support has steadily declined since then. And all of these points all of these indicators point to a clear trend that the country is rejecting the death penalty. It's a costly, flawed government program that risks killing the innocent. Again, just last week we had another man walk off death row in Texas. 153 people now have been, lives have been spared. We don't know how many have been executed, but we have 153 people who've been taken off death row due to innocence. Not technical problems, but innocence. That should give us pause. Every week we execute, we also release people from death row. It should be a concern. And studies have proven that the death penalty is racially, geographically, economically biased. No matter where you are, no matter what state you're talking about, you've got this evidence. Our evolving standards of decency point toward a conclusion that the death penalty violates the Eighth Amendment, and these trends establish it even further. But these trends are threatening executions, and so we come to what states that are absolutely committed to killing people need to do to make sure that the executions happen. The work of a few states that do want to execute is really a last-ditch effort. It's a last gasp of the death penalty, I would say, kind of the fervor before the end. And that is evidenced in two main developments that I would say we've seen a lot of this past year. That's some states resorting to obsolete, outdated, unconstitutional execution methods like electrocution is been passed as an alternative. If lethal injection proves impossible to implement, we'll go back to electrocution in Tennessee and Alabama. Hanging is still on the books in New Hampshire. Firing squad has been passed in Utah and Oklahoma this year. And the gas chamber has been brought back in a way in Oklahoma as an alternative. But the real kind of, I don't know, juiciest or most disturbing development that states are resorting to is the secrecy laws that have caught on like wildfire in the few states that want to execute, that are committed to executing. I think that the thought pattern has gone such that, well, you know, if you hide the source of the drugs, if you hide the supplier of the drugs, if you also hide information about which drugs you're going to use, how you're going to mix them, who the participants are, from the original development of the drugs all the way through to the actual implementation of the execution, including executioner and any medical personnel if you're lucky enough to have medical personnel involved, and a lot of the actual procedure itself, what goes where, when, then you might get away with it for a few more times, a few more years. And certain states are committed to that. So you have 12 states now that have some version of secrecy laws on the books, either concealment of execution methods or secrecy of the supplier. Those states are Arkansas, Arizona, Florida, Georgia, Louisiana, Missouri, Ohio, Oklahoma, South Dakota, Tennessee, Texas, and Wyoming. There's litigation pending in each of these states, or anticipated in each of these states, and the litigation is done through claims by prisoners regarding their right to know about the details of their execution, claims by the media on First Amendment grounds, that's also going to be discussed here, and human rights claims to international human rights bodies that this is a violation of human rights law. In 2015, we had a couple of new laws on the books passed in Wyoming, where there's now no one on death row, so that law is hopefully not going to be enforced anytime soon. In Arkansas, the secrecy law passed, and the next day, litigators went to court because it clearly violates the established protocols in the state. And Texas, which is not a surprise. That actually Texas now wants yet another way to make sure that it can execute people. We still have secrecy laws pending in Alabama and North Carolina. Those legislative sessions for 2015 aren't done yet. And most importantly, I think more secrecy bills have passed or have not passed or failed or been withdrawn this year than did pass, and that was in four states this year. The laws didn't pass or were withdrawn. In Virginia, Idaho, South Carolina, Mississippi, not bastions of liberal thinking, these states, not run by folks who don't want to execute, not led by decision makers who are objecting to executions. But in these four states, for different reasons, secrecy laws didn't pass. The limited but fervent popularity of execution drug secrecy laws and rules in a few states serves as a last-ditch effort. And I'm going to stop here because I was asked to just set up things, and we'll have more detail from additional speakers. And you can ask me questions as we come back.
Thank you so much, Tanya, and that's very, very helpful. Before we turn to Mark, let me ask you one provocative question. I could imagine, say, Justice Samuel Alito listening to your presentation and drawing the conclusion that part of the reason that we have these shortages is pressure from death penalty opponents, from European governments, from the FDA. And he might say, as he did in the argument of the Glossop case, that what he sees is a guerrilla war against a lawful, constitutionally mentioned penalty. What would you say to this guerrilla war metaphor?
Well, I think it's very interesting to me that, you know, those of us with the slingshots are being aligned as folks engaged in, you know, maybe an equally resourced guerrilla war, because that's, you know, the reality is if we were doing something like that, it would not be a fair fight. But more importantly, I think that's ignoring the issues at hand, which are the manufacturers of drugs that have been used to execute people did not manufacture these drugs with that intent. And so when they're made aware that their drugs are being used off-label and illegally, and the FDA and the DEA find out that these drugs are in the U.S. for these reasons, off-label, illegally, and they raid, Georgia, Mississippi, Alabama, a couple of other states have been, their stocks of execution drugs have been raided because, they're there in violation of the law. That needs to be what's focused on. And if the companies decide to respond to their drug being used inappropriately, and we get credit for it, it's an interesting confusion of reality and how things have developed.
Thanks. Mark, when I look at your background and resume, I might think you'd be on the other side of this issue, but apparently not. And I think maybe that's emblematic of some trends you might talk about of where the politics of this are these days.
Sure. Thank you, Adam. And again, thanks to ACS for having us here. So yeah, a little bit about sort of my journey and where I'm coming from, because I can't, none of us can sort of separate our views from our biography, I think. So for me, I served in the legislature of Virginia for 10 years. I was in the Senate from 1988 until 1998 when I was elected Attorney General. So from 1988 to 1998, all across America, we were, those of us in state legislatures and in Congress, were all busy getting tough on crime. It was a pretty bipartisan effort, actually. So for example, in Virginia, we instituted 3 strikes and you're out. We abolished parole. We reduced the age at which juveniles could be tried as adults from 16 to 14. We instituted truth in sentencing. We passed a lot of minimum mandatory sentencing laws, and we built a lot of new prisons. And when we couldn't fill those up in Virginia, we took some other states' prisoners in part, charged them a per diem, and made some money. So the corrections industry, getting tough on crime, was big business, big political business, big business all across the United States. Now, for most of us that were involved in that, we had really good intentions. We thought we were doing the right thing to keep the public safe. A lot of good intentions by legislators many times that go awry. So what happened as a result of a lot of the things we did in the late 80s and 90s, and again, this happened all across the United States, is America now and has become, we have the highest per capita incarceration rate in the world. Second to nobody, except maybe North Korea. We don't know too much about them. We have over 2 million people behind behind prison walls. If you actually factor in or think about it this way, and that is the number of people that are not only incarcerated, but are either under the direct control of a local, state, or federal correctional authority, such as probation, the numbers get even higher, such that you've got 1 out of every 100 Americans who are actually under some kind of supervision that's related to the correctional system. If you look in minority communities, particularly the Hispanic community and the African American community, it's an absolute disaster. And many African American communities throughout the United States are really being hollowed out generationally by the high incarceration rates. So all of this happened. It had this results, but we're living in a little different environment now than we were in the late 80s and 90s. Why is that? Well, I think one of the reasons is, well, first of all, I should say after serving for 10 years in the Senate, I then served 4 years as Attorney General, and by that time I'd sort of gotten tired of being tough on crime, only in the sense that we couldn't find anything else to do. What else was there left to do? So we didn't do much else. It sort of became static. But during the time I was Attorney General, we had 36 executions in Virginia. And I was only Attorney General for 3.5 years. And so during that time, I participated as the Attorney General in charge of the lawyers in our office who handle all of the appeals of death penalty cases from the lower courts all the way up to the Supreme Court. It had a pretty significant effect on me, but not too much at the time. It really made me, I was beginning to really be troubled about the death penalty, but not in a way that I really wanted to have a serious conversation with myself, because I was getting ready to run for governor. And in Virginia, if you were going to be against the death penalty, you might as well just walk away from politics, be you a Democrat or Republican. So I sort of walled off my doubts about the death penalty. I'll come back to that in a minute. So after serving as Attorney General, I ran for governor. I came in second, which is the same as losing. And I then went into the nonprofit sector and became president and CEO of a nonprofit called Prison Fellowship, which happened to be the largest outreach in the world to prisoners and their families. So then I began visiting prisons all across the United States and the world, and boy, did I get an education. None of the people that I served with in the Senate really had spent too much time in prisons. Every legislator gets taken into prison, but you get the warden's tour, right? So it's kind of like getting the principal's tour of the school. You don't really know what's going on with the student body. So in the course of 10 years visiting prisons all across the United States and dealing with inmates, I really saw firsthand that there's just an awful lot of people in prison who don't need to be there. People who we as a society were angry with, but they're really not a threat to society. So the other thing I began to realize is I did a lot of speaking to Rotary groups, churches, in my role in Prison Fellowship. All of a sudden, I began to realize that because we now had over 2 million people incarcerated in the United States and so many people on probation and parole, there wasn't anybody now in America who didn't have a family member or a loved one or a friend in prison. Contrast that to 40 or 50 years ago, that just wasn't true. But today, I could ask for a show of it. Maybe I will. How many people here have a family member, a good friend, or a loved one who's done time in prison? Raise your hand. Well, there you go. So this has touched everybody. So consequently now, crime is no longer a wedge issue in the United States. It peaked, in my opinion, probably in 1988 with the Bush-Dukakis race and Willie Horton. And since that time, it's sort of been on a downhill slide. And today, we'll witness another set of congressional races and presidential race next year. I would suggest to you domestic crime is not going to be a front and center issue. Now, it can come back at any time, but it's just not there. It's been replaced by other things: immigration, terrorism, national security, government surveillance. So all of this has resulted in a lot of bipartisan efforts across the country in state legislatures to sort of try to step back from the excesses of the 80s and the 90s that resulted in over-incarceration. It's been a bipartisan effort. So how's the death penalty fit in? Well, the death penalty is part of what we did to get tough on crime in sort of really shoring up the death penalty in the 80s and 90s. And just like over-incarceration touched pretty much every family and individual in the United States, the Innocence Project, the advancement in forensics, has touched every American in terms of their level of understanding how confident we can be in a human-run criminal justice system. Among conservatives, what's happened on the whole crime issue and is happening on the death penalty issue is they've sort of woken up and realized, part of what's in my DNA as a quote-unquote conservative is that I don't really trust large bureaucracies and large government entities because they're too subject to abuse of power, too subject to corruption, too subject to just getting it wrong. And lo and behold, that's been true in the death penalty. Now we know too often, if we didn't know before, maybe we should have, that it's been administered without impartiality, with corruption, with bias, with discrimination, and using forensic science that was bogus. And every generation thinks we have reached the cutting edge of what's true in science, only to find out 20 to 50 years later we haven't. So what's that's resulted in is, among myself and a lot of other people like me, in sort of that have traditionally been conservatives in their political life, is having a whole different view of the criminal justice system and what's possible and what's desirable. You have organizations like Right on Crime, which have people like Gary Bauer, Newt Gingrich, all kinds of people who've been on sort of the right side of cultural war issues, now saying, you know, we need to reform the criminal justice system. Now, these people haven't necessarily gone to saying we oppose the death penalty yet, but I think it's an inevitable journey. The secrecy issue that's come up has been really interesting, and I just want to jump to Adam's question, because I thought it was really interesting, you know, listening to the argument when Judge Alito said, well, you know, this whole thing about the drugs isn't just really this just guerrilla warfare to get rid of the death penalty. You know, probably one of the reasons I would never be a good advocate before the Supreme Court is I would have said, so what? What difference does it make? You know, for people who were pro-life, you know, that's what people who weren't pro-life said about parental notification and partial birth abortion. And yes, they were right. It is guerrilla warfare. But if you're going to eat an elephant, what do?
Take the first bite.
Take a bite at a time. And, you know, it's not as if the secrecy laws and the way drugs are approached in the prisons ought not to be changed anyway, whether the death penalty stays or it shouldn't stay. So it's really, you know, I understand why he was asking the question, and I'm sure some of the vote on the Supreme Court will reflect people's view of the death penalty, but these issues stand on their own. And again, generally, if you're skeptical of big government and big bureaucracies and power, you ask yourself, why is something secret ever in government? Well, there's usually two reasons. One, if it were not secret, you'd be called out because what you're doing is wrong. Or two, there's an argument about public safety or national security. And both of those arguments are advanced by those who want secrecy laws in the states. Number one, well, we have to have this to secure, you know, to have a secure system and to promote public safety, because without it we can't do the death penalty. And two, they know that if there weren't secrecy laws, there would be significant pressure brought to bear that would take that option off the table. So I'll stop there and look forward to coming back later.
Let me ask you one quick question, just maybe a kind of reality check. In 2008, the Supreme Court ruled that the death penalty only applies to murder. That is, you can't execute, say, a rapist. And the day the decision came down, Barack Obama, then the candidate, promptly denounced the decision as wrong. Do you see a candidate in a major political party coming out against the death penalty? A presidential candidate from or when do you see that happening? Because that might have been quite a, you know, you would not necessarily have expected that response from.
Right. I think it, you know, I would have said, you know, until recently that no, you wouldn't see that, not after what Michael Dukakis endured in 1988 when he tried to explain why he was opposed to the death penalty. But I do think you will see that in there. I mean, I actually think the death penalty is probably going to be extinct. But I do think we're going to be a while from getting there. And to the extent, you know, terrorism continues to be a threat, and it will, there's always going to be that argument, well, what about, you know, the mass murderers? And as I've often said, you know, I can make an argument that I think has intellectual credibility that conceptually there is a place for the death penalty. The problem is we can't get it right all the time. And if you can't get it right all the time, you cannot have a death penalty, because our whole system of justice is based on the fact that we would prefer that 10 guilty people go free than one innocent person be convicted. And in the case of death, you can't reverse the error. But you could still keep the public safe. This escape in New York doesn't help any of these discussions. But there will always be escapes. And again, it's just an example of the failure of government to always get it right. You know, we never underestimate the people, the ability of people, any of us who run something, to have a massive failure or to be corrupt or to do something wrong. And so that's why I just think, you know, it's the best argument against the death penalty, and one I should have embraced years ago, quite frankly.
Well, maybe that's a good transition to Megan, who's going to tell us about litigations over just these kinds of really appalling failures.
Okay, thanks, Adam, and thank you for having me. I don't underestimate my own ability to have a massive failure.
Nor should you.
So I guess I have so many different ways I feel like I could go to talk about all of these issues. So I will try to drill down a bit on the secrecy itself, the secrecy surrounding execution procedures, and some of the statutes around that, and more specifically the litigation that has been getting after this secrecy, trying to get around it and get rid of it. Adam mentioned the Glossop Supreme Court case that the court heard at the end of April and should decide, we think, sometime this month. Secrecy is not an issue in that case, and yet it's still there. It's still part of the story. Secrecy was specifically litigated. Secrecy surrounding the execution procedures in Oklahoma was specifically litigated prior to the botched execution of Clayton Lockett, which in turn led to the Glossop litigation, which is now in front of the Supreme Court. Oklahoma is one of the states that has a secrecy statute. And what we've seen with secrecy around execution procedures, it's always been there. But what we've seen more recently is that it is getting, I like to say, deeper and wider. More information is becoming confidential, is being deemed secret. And the level of secrecy around that information is more intense. I think the best example of sort of the intensity of that secrecy would be the secrecy statute in Georgia, which defines information about the source of the drugs, the executioners, other specific but relevant information about the execution procedure. There is deemed a confidential state secret. There is no higher level of secrecy, and that means that even a court that says there is a valid Eighth Amendment question here, there are valid due process, right to know, access to the court claims here, that court cannot order the disclosure of that information and get it. That should be an outrage to the court, to the public, to everyone, and yet that statute was upheld. And so what we see is secrecy that's always been there, certain types of information, and most often, of course, the identity of the executioners. That secrecy is just becoming more and more enhanced. So Oklahoma has one of these secrecy statutes. So information about the sourcing of the drugs, the provenance, that is prevented from being disclosed. And what that means, not just in Oklahoma, but anywhere where that information is not disclosed, I mean, what you're really getting at is that prisoners and their legal teams are prevented from knowing how they will be executed. So they will know this drug is going to be used, or in the case of Oklahoma, these 3 drugs will be used. But if you don't know the provenance, the source of those drugs, are they manufactured FDA-approved drugs, or are they compounded drugs? And if they are compounded drugs, where are they coming from? What are the ingredients? Who or where is the compounding pharmacy? Because increasingly, we don't even know if the compounding pharmacy is in this country, much less in the state where the execution is happening. And if you don't know what the drugs are, you don't know how the execution is going to go. And so that really is what's at stake. They can say, a state can say, we will use midazolam, but if you don't know what that midazolam product is or what the pentobarbital product is, there's a real risk. Okay, sorry, I keep getting off track. Oklahoma has the secrecy statute. The litigation before Clayton Lockett's execution was in state court under state law, under the state constitution, challenging that secrecy. And so they were challenging it as an issue of a right of access to the courts, a right to petition for redress, and a right of access to information. The Oklahoma trial court found a violation of the Oklahoma Constitution on those grounds. And then a lot of political hot potatoing happened. So there was the ruling, but no one would give Clayton Lockett and Charles Warner a stay of execution. The trial court said they didn't have jurisdiction. The Court of Criminal Appeals said they didn't have jurisdiction. The Oklahoma Supreme Court said they didn't have jurisdiction. And so time was passing, and there was a lot of fighting and kind of craziness that I can't claim to understand. And then eventually a stay happened, and more political firestorm happened. And so the Oklahoma governor harshly criticized the members of the Oklahoma Supreme Court who granted the stay, and the Oklahoma legislature drew up articles of impeachment for those justices for putting a stay in place. Understand, this was a stay to give them time to review the appeal of the ruling. And so quickly after the articles of impeachment were drawn up, the Supreme Court of Oklahoma suddenly reached a decision and overturned the finding of unconstitutionality, lifted the stay, and allowed the executions to go forward. So April 29th, 2014, Clayton Lockett and Charles Warner were both scheduled for execution on the same night. This is a 3-drug execution protocol with midazolam, and then a paralytic, and then concentrated potassium chloride. The state had said that these were manufactured, FDA-approved products, and so that was what was known at the time. Some of you might know that the execution of Clayton Lockett went very, very badly. A very bad botch. He was alive for much longer than anticipated. He was struggling, writhing, gasping, speaking, moving, really surprising people. But secrecy still is at play here, because when this very bad execution happened, the curtains are closed. So we have reports, we have autopsy reports, and we have some interviews that give you an indication, some indication of what happened behind the curtains, with Clayton Lockett. But really, the only people who know what happened after those curtains were closed are the people who were behind the curtain. We've heard some words come out of the interviews like bloodbath, clusterfuck. I was like, what was that term? Those are some of the words from the people behind the curtain. But it was very bad, and secrecy is still at play here because we never will know. And then so that event led to the current litigation that is in front of the Supreme Court. That is not secrecy litigation, that's Eighth Amendment litigation, challenging specifically the use of this drug, midazolam, in a 3-drug formula for executions, and whether that drug can lead, well, I'm rephrasing it, that's not the issue. The issue is it constitutional? I would say, can it ever be counted on to carry out a constitutional execution? So that's the extent to which secrecy kind of overlaps with this Supreme Court case that we should hear decided soon. I think one of the side effects, or one of the practical implications of this secrecy, it's not just that we don't know specifically what the drugs are. We can't be sure that the pentobarbital is what it purports to be, or that that it will work the way it is supposed to work. Will it have impurities? Will it be contaminated? That is all very valid, all very true. We can't know those things. We don't know those things. But it also creates an atmosphere where, and Oklahoma is still a good example, where new execution procedures are developed. And there's no oversight, there's no accountability, there's no need to disclose, how did you come up with this combination of drugs? How did you come up with this dosing? And so it really is, the secrecy is insulating the states from that type of scrutiny and allowing them to behave in ways that they would not and could not behave if there was transparency. Nebraska, although it's a different situation, it's also a good example. The governor, in his attempts to veto the repeal, he was saying, I know there's been problems with the death penalty, but I fixed it. I found the drugs, there's no more problem, I fixed it. But if you dig a little bit deeper, what you see is that for the third time, Nebraska purchased illegal drugs from a dealer in India for the third time. The first 2 times didn't work, but they went back to the exact same source and bought illegal drugs for a third time. And it's, legally speaking, beyond question. They are unapproved, misbranded drugs that cannot enter the country. It violates federal law for those drugs to enter the country. And so, everywhere you turn, there are actions being taken by the state that will be shielded, that will not become public because of the secrecy statutes, but that we can't and we wouldn't stand for if they're out in the open.
So just to drill down on the legal piece of this a little bit, and as a transition to Katie, if you're representing a death row inmate with an execution date who wants to know how the state intends to kill him, what's the legal theory? What's the most promising legal theory to go into court and say, this is why I'm entitled to that information?
That's a very good, difficult question, because there isn't a very promising theory from our experience. So if you look at litigation out of Georgia and a few other places, if the claim is tied to an Eighth Amendment claim, so if the condemned prisoner is saying, I need to know this information so that I may present to you, court, my Eighth Amendment claim that my execution may torture me to death, the courts are saying your underlying Eighth Amendment claim is invalid, therefore you have no right to the information. You haven't laid out an Eighth Amendment
Well,
claim.
it sort of sounds like you're seeking discovery in whatever kind of proceeding this is, where you,
Like a constitutional argument for discovery.
right.
On the other hand, in states where they have brought straightforward First Amendment claims, there's been some, I think you see courts biting on that more, but there hasn't been tremendous success. So in Arizona, in the Wood litigation, also in Oklahoma, in Ohio, it's a slightly different claim. These are the more straightforward right of access to the courts, a right to petition for redress. Ohio is actually taking a slightly different tack. They're on appeal after being dismissed, however, of a straightforward First Amendment. This secrecy statute prevents speech. It prevents criticism of the procedures by denying us access to what the procedures are.
So Katie, if it seems that the death row inmate himself may not have the cleanest shot, does the press and public have a separate, different, better shot?
Well, we'll see that. I mean, I think these issues are sort of winding their way through the courts now. So as Adam said earlier, I'm a media attorney, so I bring a little bit of a different perspective to these issues. Certainly my organization doesn't take a position on the constitutionality of the death penalty itself or any method by which it might be carried out or weigh in on the policy determinations as to whether or not the death penalty is a good idea, whether it's good policy or not. What we are concerned about, and one of the reasons we've become very interested in this issue, is because I think, as Megan indicated, there's a lot more secrecy surrounding what we view to be government activity, and so we view this as a government transparency issue and a government transparency problem. In the last year or so, there has been not only an effort to have additional secrecy statutes put in places like Virginia, for example. I think the bill that was proposed in the Virginia Assembly is in everyone's materials, one of the things that was available to you, and it's extremely broad. Thankfully, it did not pass. It would have made it essentially impossible for any member of the press or the public to access information under Virginia's public records law. So just to be clear, there's sort of two frameworks through which the press or any member of the public can seek access to this information. We think there's a constitutional framework, so there's a First Amendment argument about access to proceedings, which can be the execution itself. So for example, in Oklahoma, when the curtains were drawn as everything that could go wrong during the Clayton Lockett execution was going wrong, that is a potential First Amendment violation. That issue is still being litigated, is my understanding, in Oklahoma by The Guardian and some other news organizations and reporters there. The Oklahoma Observer is another party to that case. So there's a First Amendment framework. And then there's also a First Amendment right of access to documents related to criminal proceedings. That's a little bit fuzzier, whether that applies at all. Maybe it does if there's some litigation involved, or if there's some, if things are filed in the court, but that's certainly a lot fuzzier. Generally speaking, the way the media, members of the media try to get this information when we're talking about documents relating to what the lethal injection protocol is, how it's carried out, is to utilize the state's open records or public records law, state FOIA, for lack of a better way to put it. So the secrecy statutes you see, like the Virginia one, for example, that was proposed and rejected, basically expressly either are part of the state's FOIA or brought into the state's Freedom of Information law through some provision that says anything that's declared secret for some other purpose is also secret for and exempt from disclosure under a public records law. So not only are we seeing additional new statutes, new secrecy statutes, but we're seeing older statutes that are vestiges of a time when executions were frankly public. We're talking about sort of hangings in the public square. The person who was the hangman was wearing a hood, so you didn't know his identity. And so there are statutes that have been on the books for a long time in states where the death penalty is carried out that talk about the hangman, basically, or that say the execution team. And by execution team, they mean the individual who is, as in the case in Oklahoma, sort of pushing the button, one of the three individuals who's sort of pushing the button to inject the drugs into the inmate, and their identity solely, nothing else. We're seeing states like Missouri, for example, attempt to utilize those statutes to deny public records requests in their entirety that seek information concerning where drugs, who's manufacturing drugs, where the drugs are coming from, just standard sort of government contract information, actually. That's the way we view it. Where the drugs are coming from, who the compounding pharmacies are, who the laboratories are that have tested the drugs, if any, how much they cost. I mean, just everything you can possibly imagine is being brought into under the auspices of they're part of the execution team if they're supplying the drugs. I think there's sort of, I don't want to repeat what other folks have said, so I'll keep it a little bit short, especially since there's not really much I can say on the policy issues. But I will say that I think this idea of lethal injection, of the unavailability or the scarcity of the lethal injection drugs, certainly underlying all of this. We're actually litigating a case in Missouri alongside the ACLU of Missouri and Christopher McDaniel, who used to be a public radio reporter in Missouri. He's now the death penalty reporter for BuzzFeed, and he does great work in this area, seeking information relating to compounding pharmacies, the drugs that are used, the laboratories. That case has been pending for quite a while. We're waiting a determination. We've seen in that case, the argument that's being made is these drugs are scarce. Because they're scarce, we had to promise. The Department of Corrections of Missouri has said it had to promise the suppliers confidentiality in order to obtain the drugs to begin with. If they are forced to release this information, they won't be able to obtain the drugs at all. So that really is what's underlying, I think, this refusal to give information that probably, if we were talking about 10, 15, 20 years ago, we wouldn't see this level of secrecy. So it certainly is, I think, the driving force. Not only are we not able to get information about, not only is that one of the, I think, factors, one of the driving factors, I think also one of the reasons that government agencies do not want members of the media and the public to know where these drugs are coming from is not simply because they think it'll be then more difficult to get the drugs, but I think they also don't necessarily want scrutiny of those compounding pharmacies. There was a great piece in The Atlantic about the Clayton Lockett execution in the June edition. If you haven't checked that out and you're interested in it, it's really a fascinating piece, a really well done piece, and it sort of drew the connection to some of how really terrible the conditions are in some of these compounding pharmacies. You may recall there was a meningitis outbreak that was traced back to a compounding pharmacy. So I think that they don't want scrutiny of that. And I think also, as we're seeing in Oklahoma, we're also representing a reporter and a news organization in Oklahoma still, a year later, trying to get access to email related to the execution of Clayton Lockett from the governor's office and from the Department of Public Safety. We still have not been able to get. I think in some cases the secrecy is tied to what Mark pointed to earlier, a strong desire not to have scrutiny where there has been something that has gone terribly wrong. So I'm not saying that that's the case in necessarily all of these jurisdictions, but certainly in Oklahoma, where the execution went terribly wrong, that seems to be a driving factor behind this.
So Katie, are these litigations for the most part under the State Open Records Act?
So it's a bit of a mix. Our litigations are. So we've focused primarily on the State Public Records Act, the Oklahoma case and the Missouri case. There's a companion case in Missouri that's being litigated by the Guardian that is a First Amendment and public records case. It's on the same track as us. It was briefed and argued at the same time. They make a First Amendment argument. So it's been a bit of a mixed bag. It depends on, I think they're both frankly good arguments, so I think it's good to pursue both. I think we'll have to see sort of how it plays out.
But I take it if there's a separate state secrets statute, that would overcome the open records argument and you'd be left with the constitutional one?
Right, and there's also state constitutional arguments. So in Oklahoma, although our case is an Open Records Act case under Oklahoma's state law, there's also a state constitutional argument. Because the state has an interesting constitution with access sort of built in to the state constitution, which the federal constitution does not have.
Well, we've raised so many good issues, and I can tell from the body language of the panelists that there are some things they want to respond to. Let me ask one question to open up a more general discussion, and then we'll turn to your questions soon too. But I want to make sure that if there are things you've heard you want to respond to, you get a chance to do that. One thing we haven't talked about is an odd theme in some of the cases that you can, if you're a death row inmate, you can only make a challenge to the way the state intends to kill you if you give them a better idea. If you say, well, if you kill me in this other way, that's okay. I just object to this particular way of killing me. What do you guys think of that argument? That, or I shouldn't call it an argument, that judicial attitude in some places?
Sure, I'll start there. That is an idea that comes out of the Baze decision, and I think it's really interesting to look back.
And why don't you pause and say a word or two about Baze?
Sure. So Baze v. Rees is a Supreme Court case that was decided in 2008. The case came out of Kentucky, and it looked at the constitutionality of Kentucky's execution procedure, which at that time was a 3-drug protocol, where the first drug was a barbiturate anesthetic. Looking back, from today's vantage point, looking back at the Baze case, it's very interesting because the petitioners coming out of Kentucky were arguing to the Supreme Court that they fully conceded that the protocol would be humane and constitutional so long as it was administered properly. So if that first drug, which was an anesthetic, was administered properly, the petitioners conceded that the execution would be humane. And so the argument turned on the risk of maladministration. And then the petitioners in Baze said, given that there is a real risk of maladministration for this list of reasons, it would be better, it would be constitutional, the procedure would present less risk of an unconstitutional execution if, and then they proffered 2 alternatives. One was the state used a 1-drug procedure instead of a 3-drug procedure, so no paralytic and no concentrated potassium chloride, or there was a medical professional present in the chamber in charge. And so that's where really the idea of proffering alternatives came from the petitioners in Baze who proffered alternatives because they were conceding that the procedure was constitutional so long as it was administered safely. The first alternative, just use 1 drug, took away the risk of pain and suffering that is created by the 2nd and 3rd drugs. The second proffered alternative puts a medical professional in the room to make sure that the prisoner is under anesthesia before those dangerous drugs, the drugs that would cause the pain and suffering, would be administered. So I just think it's very interesting to look back at where that idea came from and then look at it through today's lens, where the Glossop case in front of the Supreme Court is positioned completely differently. They do not concede that the procedure could ever be humane, could ever be constitutional, but instead say that first drug cannot and will not put prisoners under anesthesia sufficient to protect them from the pain and suffering of the second and third drugs. And so I think given that, it's really interesting to think, if you have a concededly humane procedure, then does it make sense to say we're not going to order the Department of Corrections to change it unless you give us a better option? Versus you have a situation where you're saying this procedure violates the Constitution. It is unconstitutional. And, there's no other context in which we would say it is the petitioner's responsibility to give us the solution.
Other thoughts on that, or any of the issues that I've failed to follow up on properly?
I would just second the suggestion, if you haven't read it, to read the Atlantic article about the Clayton Lockett execution. If it weren't such a serious issue, it would be funny. It almost reminds me of an old Tim Conway skit on the Carol Burnett show many, many years ago, where he's a dentist trying to inject Novocaine into a patient, and he ends up rendering himself totally numb because he gets the needle wrong. But the whole unfolding of the Lockett execution, the embarrassing role of the governor and the state judiciary, just in sort of the legal aspects of it, the paramedic, the doctor, the difficulty. I mean, it took them an hour to try to get a vein. Whenever you go to the doctor, you're always hoping they get it on the first time. And, they were an hour, and then it just went on and on. I mean, it was just totally incompetent. So it's the kind of thing that when you start to peel back the curtain on what everyone wants to keep behind closed doors, it continues, going back to the issue of the death penalty at large, to erode confidence in the ability to not only not execute an innocent person, but when executing someone who is clearly guilty and who arguably may deserve the death penalty, the inability to do it correctly.
Let's turn to your questions. There's a microphone up there. Don't be shy. These are really excellent folks with a lot of ideas. I guess I didn't need to say that.
Let's see if I can do this. Hi. Good morning, everybody. Antonio Ginata from Human Rights Watch. The strange postscript to the Clayton Lockett execution, I remember Mary Fallon, the governor, did a review, and one part of the recommendations in reforming the process of executions in Oklahoma was to reduce the number of media who can participate and watch the execution. I'm just curious about the secrecy argument. It's more of a question for the panel as a whole. Is the secrecy driver about protecting businesses from harassment and from public persuasion, public pressure, apropos the Alito comments and Glossop, or is secrecy really about keeping the death penalty and the application of capital punishment antiseptic and clean and clinical and keeping it away from people seeing it as gruesome or bloody or messy as it was with Lockett? Which is the real driver? Or is it both? Is it one more than the other?
I actually think it's a third, which is just a desperate measure. Not about keeping it clean, not about protecting anyone, any one particular business or another, but just making sure that there's a way to implement the death penalty because of absolute commitment to the death penalty itself. And so I think that, there are other pieces that might be used depending on who you're talking to about it, but I think fundamentally when you hear folks who are litigating these issues and talking to the AGs or talking to the legislators or talking to whoever is involved in making the corrections folks, they just need to get the job done. And that's kind of the approach. And so this is another vehicle.
And I just will add to that, and I don't want to necessarily speculate. I think there's a lot of things at work, and so I won't necessarily speculate as to sort of one motivating factor on this. But I think what's so telling and so instructive about the Oklahoma Clayton Lockett situation is how the secrecy laws and the delay in being forthcoming with information from the governor's office and the Department of Public Safety has really impacted the democratic process when it comes to the public's ability to make decisions about whether or not the death penalty should continue, to really participate in that debate. While our public records, or my client's Public Records Act requests were pending, they were submitted within days of Clayton Lockett's execution in April of 2014. In the time that they've been pending, because they're still pending, we haven't gotten information. The Oklahoma legislature passed new death penalty legislation authorizing use of a gas chamber. There was a robust debate. The Warner case and then the Glossop case, which became the Glossop case, was working its way through the federal courts. The United States Supreme Court was hearing arguments based on documents that had been filed under seal, that had been kept under seal, that were provided to the Warner then Glossop parties, or the defendants, or the parties in that case, not really the defendants in that case, but the parties, but had never been made public. So all of this is playing out, and all of these important policy and legal decisions are being made without public knowledge about what actually happened. It's only now in March when, because of our litigation, the Department of Public Safety and the governor finally released the transcripts of the DPS investigation, from the DPS investigation, of people like my client, who was a media witness, who couldn't get access to her own transcript, that showed, for example, that Clayton Lockett helped them find where he had a vein in his groin after about 50 different times of them trying to poke him everywhere else. That was not known to the public until this past March. So that just demonstrates how this secrecy and this desire by the government agencies who are carrying out the death penalty to keep the public in the dark really does impact the democratic process and really does impact the ability of the public to tell their elected officials, we don't think that you're doing this right, if that's what they think, or maybe we should reconsider whether we do the death penalty, if that's the response. So I think the timing of that case and the way that case played out has really, really underscores the importance of meaningful public access to this information.
Yes.
My question is more general, just about how you think the death penalty will be abolished. And before I went to law school, I worked as an organizer for a group called Witness to Innocence in Texas. We worked with exonerated death row inmates, and before that I was an activist working with local groups fighting the death penalty. And the one thing that those of us in Texas specifically noticed was the millions of dollars that are being spent in fighting the death penalty go to states that don't really execute anyone. So Nebraska ended the death penalty the other week, but they had only 3 executions since 1976. New Jersey in 2007, they hadn't executed anyone in 26 years. And they received tons of the national money that went toward ending the death penalty. So to me, that sounds like saving the whales in Iowa, because it doesn't work. While people are getting executed every day in Texas, Virginia, Florida, and other places. And on the other side, the reason that this is happening, the national strategy that the funders are using is that, and I would like you to comment on that, is that they looked into the other cases that of execution of mentally ill juveniles and so on, and they found out that once 20 or 25 states banned the execution of mentally retarded the juveniles and so on, then the Supreme Court uses that as a change in mindset of the national mindset and uses that as a reason while they will ban that. So do you see that in 10 years or 15 years, once we get 25 states ending the death penalty, is the Supreme Court going to come and say, abolish the death penalty using that reasoning or something else?
When the number of states that still have a practice like that is very small, the Supreme Court does sometimes come in as a kind of mopping up operation. But we're a long way from there, and I think the composition of the court would need to change first.
I think that the number of states that have gotten rid of the death penalty or don't use it, which is why I included the 7 or 8 states that haven't put anyone to death in 10 years, in my count, matters to the Supreme Court. But in this context, I think reducing executions and reducing new sentences will also play into their consideration. I think that decisions are made, and I don't know, I'm not privy to the states that you're talking about, one over the other. But I think that decisions are made when you're looking at the states that have a repealable death penalty versus states like Texas, where repeal is not a viable strategy and something else may be. So decisions are made in terms of, focusing energy in one state over the other along those lines. But all the states need to be moving away from the death penalty for the Supreme Court, I think, to pay enough attention. But nobody knows what the actual numbers will be for them to take the right action. And I think they're very resistant to it in a lot of ways. And we've seen historically them carving out ways for it to continue hobbling along, but still, not found unconstitutional. So we're still a ways away from it, but I don't think we're 10 years away from it. I think we're less than 10 years away from it.
My question is about the private drug companies. Do they always know when their products are going to be used in this way? And if they don't, I see you shaking your head. If they don't, do they have a right to know so they can then refuse sale or block export? And as a follow-up, if they do have that right, would it not be better or more effective to go through those private companies and use their right to really attack these secrecy laws rather than the rights of a single defendant?
Right. So I will answer this as best I can, but with the caveat that this is not really my area. So the general way that it would work, it being the sale of drugs in our country, is that pharmaceutical manufacturers make their drugs and then they go off into the stream of commerce to another company that distributes them. And so once they leave the manufacturer, the pharmaceutical company, they really don't know where their drugs go. They know how much they sell and stuff, but they're not keeping track of every sale. They have distributors for that. And they're big brand name distributors. McKesson is one. There's like a handful of the big distributors. So generally speaking, no single pharmaceutical company would know that their product is being used in an execution. There are exceptions. So when pentobarbital was really the one drug that was being used as the anesthetic, there was only one FDA-approved product of pentobarbital, so everyone knew it had to be that product. So that's where the second part of your question comes in. For longer than the legal community has been paying attention to execution procedures and the drugs used in them, pharmaceutical companies have been paying attention and have been saying that they don't want their products to be used. And so you can go back and find letters from pharmaceutical companies to governors and departments of corrections from 2003, 4, 5, 6, saying, please stop using our drugs in executions. That's not what we make them for. It wasn't until 2010, 2011 that pharmaceutical companies figured out they could in fact do something about it. And they started doing things about it. So Lundbeck, which is the company that used to sell the pentobarbital product, they put a different distribution system in place to prevent the use of their drugs in executions. And so rather than sending off pentobarbital to a regular distributor, they now control the distribution of their drugs. So it required them to put a new system in place. Financially, I don't know how any of that works, but they no longer do that just sort of general send our drug off into the world. They do what's called a drop shipment. And so it's no longer their product. Now a different pharmaceutical company owns the product. But they know every single buyer of the drug, and every single buyer of the drug signs a contract saying they won't resell it to a Department of Corrections. And so they are able to ensure that their products are going to healthcare, medical care. So once that happened, the flip side of that is that once the brand name product is called Nembutal, once they put that distribution system in place, Nembutal became unavailable to Departments of Corrections. Departments of Corrections shifted to compounding pharmacies.
Thanks.
Hi, thanks to you all for being here, first of all. I have a somewhat convoluted question. I was once a legal intern at the ACLU National Prison Project, and as you probably know, they work a lot on, they do a lot of cases based on inadequate medical care in prisons and jails. And I'm just wondering about this idea that the inadequacy of medical care in prisons and jails, which is, very common, can result in the deaths of prisoners, and if that isn't, in essence, the imposition of a double sentence, basically that you've essentially sentenced someone to death, possibly if you, given the inadequacy of medical care in prisons and jails, and if you could make some kind of due process argument based on that, or if it relates to secrecy, in that judges and juries are not aware of the actual implications of the sentence that they're imposing.
It's a good question, but I think you're right to call it convoluted. Who would like to field it?
Well, I'm willing to say just that there, the corrections department is charged with implementing the sentence. And they don't, they're the first one to say, we don't have anything to do with what the sentence is. And so, there are two branches of government then here at play, and the interactions of the two are going to be a hard piece to negotiate, to have the sentencer then weigh what the implementer is doing. But I encourage you to pursue it. It's novel. It's an interesting idea. But I'm sorry, I don't have much more than that.
One thing you're really right about is you don't want to be sick in a prison. You don't want to be sick in a hospital, but you definitely don't want to be sick in prison, particularly with a chronic disease.
They'll apparently give you the drugs you don't want to keep,
right.
but not the ones you might
Well,
want.
and you're seeing that with the hepatitis C issue now, like with, a chronic condition. If they don't get those extremely expensive drugs, it's basically.
I have a client with AIDS, and what he was taking on the outside was a very expensive, a very exquisite drug that was keeping him at a certain level, but trying to get him that in prison is next to impossible.
Thank you.
Thank you.
So quick background is that I worked for the Ohio Innocence Project this past year, in which we exonerated actually 6 people just this year, 2 of which at one point were on death row. While working with that, there was an intern, a legal fellow from Ireland, who their maximum prison time is much, much lower, I think 30-something years. And she talked about the trends in that there was very little repeat offenses once they got out of prison. So I guess my question is, as the country's moving away from at least the death penalty, is it that we're really moving away from being as tough on crime, or are people just saying the policy reasons, it's too expensive, it's not effective, but we just want everyone to be life in prison? Or is it that we're kind of moving away as a society in terms of maybe trying to rehabilitate more and get these people back out into society?
Let me endorse and even sharpen that question, because I wonder whether the death penalty abolition movement bears some guilt for impressing so hard that the right alternative sentence is life without parole, which is essentially unknown in the rest of the world. I mean, sentencing someone to die in prison and to take away all hope from that person, often at a very, very young age, is an extremely harsh punishment and almost distinctive to the United States. And it's partly because you heard about the polls. Well, isn't it better? Well, I suppose it's better than dying, but not by much. And so to sharpen the question, are there strategic decisions that the movement makes, and does it worry that in combating one kind of terrible punishment, it encourages another?
Absolutely. So this is something that is very concerning, because every death state now has life in prison without parole as another punishment. So if the death penalty is abolished, by default, most folks, if not all, will be subject to life in prison without parole, which is death in prison, which is unacceptable, which is right. And it is very important, I think, to make sure that the arguments against the death penalty don't reinforce life in prison without parole, because that is another punishment that's unconstitutional and should be unacceptable. I think that in heavy death sentencing states 10, 15, 20 years ago, it made a huge difference to jurors who were concerned about public safety, that there be a way that people be locked up forever, that they didn't have to worry about it. And so the response was life in prison without parole. Because there was not a lot of thought given to how to change the frame for this discussion. Like, why are you afraid of people? Why does fear need to be the motivator? What other alternatives are there? How do we need to think about this as a society? What is this going to do to us in the long run? So we turn to your generation, right? The beauty of this is that we're evolving as a society, and the conversation is different. And what's defined as a conservative viewpoint now is much broader than it was 10 and 15 years ago. And so there's a possibility that more of that conversation can be injected into how to deal with life without. But it is, as someone said a couple of weeks ago, a deal with the devil to get rid of the death penalty, and it is the devil. So the work is not done. We can't stop at life without, and leave that as the answer.
So we're almost out of time, but there's one more person in the line who's been very patient.
Last week, the Ohio Supreme Court heard oral arguments for a case whose name is escaping me, but a prisoner who was on death row and stabbed 18 times trying to find the needle. And so they brought an Eighth Amendment challenge because they're trying to kill him again. So my question, I guess it's more of a thought experiment, but what's the best way to, especially in a state like Ohio where executions occur every month at least?
Not right now, they're all on hold.
Right, exactly. But is the answer that kind of litigation, given the questions that we had about who has jurisdiction, how can we stop this, or with all the secrecy laws to increase public knowledge, because a case like that, you would expect it to be way more publicized than it was, and the knowledge about how many hours they tried to find a vein that didn't work, and that. So maybe your thoughts on the best way to tackle this kind of situation. Is it the litigation? Is it working around these secrecy laws?
Well, I'll start again. I don't think that there's one answer. I think that there are lots of places where decision makers are, and you need to figure out where they are and then meet them there. So if it's through the courts, that's one way. If it's through the legislature, that's another. If it's public opinion, public education, if it's the fact that people, when I was much younger, I thought that they just don't understand. So if people just knew what was going on, they'd be just as concerned as I am. And I think that that's still really true in a lot of ways, especially if your issue comes to the ballot, or if it's a kind of, public consumption level matter. But I don't think that there's a magic bullet. Unfortunately, I think we'd be better off. We'd be able to streamline our resources better and all that. But I think that there's also lots of ways that you can make a difference without really knowing that you're going to get the outcome that you want. So I encourage folks who are thinking up novel, creative, new, different ways to address it. You're in it, like in the secrecy context. We're in a situation now that we couldn't have imagined. We thought lethal injection would be like euthanasia, and there would never be an issue with it. And when it became the method of execution over electrocution, we thought there will be no claims to come from this. And look at what happened. So you never really know. I think, I'm not going to proselytize, but yeah. Thanks.
Final thoughts from other panelists? If not, then please join me in thanking this really wonderful panel.